The additional issue becomes the custody issue. All right, this is the nuts and bolts. So first thing there is residential custody. That means the primary place the child lives. Residential custody has to do with one thing and one thing only: child support. The non-residential parent pays the residential parent child support. Now, there's sole custody, joint custody, and final decision making. Sole custody is granted to someone and they have the exclusive right to do anything they wish with the child, as of course in their benefit, not an injury. So that means in that same first scenario where mom leaves with the two kids, if she has sole custody, she can pack up and move to another state. She can change the kid's name. She can do anything she wants with their education, their health, their safety, their welfare, as long as it's not damaging. Joint custody means that you have a right to information. This is an important point. Joint custody doesn't mean you automatically have a togetherness. What it means is you have a right to know about health, safety, welfare, education, medical, camp for the summer for that matter, private school, and yes, religion. Now, the next piece of that is decision making. This is the number one thing that lawyers miss and they don't talk to their clients about because they keep telling them, don't worry, I'm going to get you joint custody. Decision making is who makes the major decisions about the child's life. What's a major decision? Health, safety, welfare, education, college even is a major decision. So why is that relevant? Because if someone has final decision making, that means they get to make the primary final decision about education. I'll use an example. The child gets tested and needs something called an IEP, which is just assistance for a child in school. And mom goes to the IEP, doesn't tell dad, and decides the kid needs an IEP and medication. Because why? Because that person has final decision making. Does that mean the other parent is precluded? No. What it means is you now have to race to court without any information, get the information, and then claim to the court the information itself is impractical, incorrect for the child, or not in the child's best interest. What's the better solution to that problem? A joint custody application where there's a decision-making clause that says each parent shall be notified of all major decisions, and they're listed, and they shall attend. And usually what I do is I put an experts clause in that says you'll attend, you'll listen to the expert, and you will follow the expert's advice.